and maybe Congress could do better.
Mr. Fisher, often we require divestiture for antitrust reasons, for example. And as I take it, your argument here, and we don't think of those as normally implicating the First Amendment interests of users or people who might speak or associate with editors. And the difference here is, as I understand it in your mind, that this law is motivated by a content-based interest. Is that a fair summary?
I think that, and the only thing I would add to it is just the prior step, which it is regulating the speech itself for content-based reasons.
Yeah,
yes.
We don't do that in the antitrust area, but
exactly.
You say this law does. Okay.
Exactly.
And it does on the covert content manipulation side. Do you think that's a compelling interest or not? Forget about the tailoring for a moment.
No, my point is that preventing content manipulation, whether it's covert or not,
is simply not
impermissible if what you mean by content manipulation are the kinds of interests the government is saying, like undermining trust in our leaders, undermining trust in democracy. That's Whitney and Abrams, and like those cases.
I got it.
Yeah.
I got it.
So, Mr. Fisher,
just a couple more. I'm sorry. I'll finish up real quick. And so that would take us to the tailoring question, and there you say disclosure. And alerting Americans that there is covert content manipulation possibility, putting aside the data collection part of it.
Yeah.
Telling Americans that there is covert content manipulation going on in TikTok, or at least it's possible. And the government says that's just simply not enough. And the D.C. Circuit did too, and I wanted to give you a chance to respond to that.
Right, so I think that's the only aspect of the governmental interest that could be permissible, the covert part. And my answer, as you just said, is disclosure solves that problem. And you have a law, a long-standing law, which we haven't talked about yet today, that gives you that example. Again, under a history and tradition test, you look at not just precedent, but laws and our traditions of our country. Look at the Foreign Agent Registration Act, passed in the run-up to World War II, and the concern was Americans would be controlled by foreign agents to speak and advocate certain causes.
We didn't ban them.
You did not ban them. All you did is require, Congress, all Congress did was require disclosure.
Certainly wasn't. I wasn't around for that. On the secret evidence point, I'm concerned about the government's attempt to lodge secret evidence in this case without providing any mechanism for opposing counsel to review it. And I expressed that concern in Zebeda, and I noted that there are mechanisms to read in counsel and that other countries, including our allies, often do that. I just wanted to give you a chance to give me your thoughts on that.
Yes, Justice Gorsuch. We made all those arguments in the D.C. Circuit, so there was a flurry of motion practice about whether or not the government could rely on classified evidence. Those motions were never resolved. What the D.C. Circuit did, I think you probably noticed from the decision, is say we're going to decide this case solely based on the public record. And my understanding is that's how it comes to this court. But if the court were ever...
It's interesting that Congress hasn't acted in this field. I mean, we have in the FISA area, lots of opportunity. They have regulated this area, and it does seem like an area that Congress might want to pay attention to, given the increased appeals to secret evidence that the government has made in recent years. Last question for you. Could the new administration, after January 20th, Mr. Francisco suggested that it might be able to extend the deadline, even though if you were to lose here by January 19th? Is that possible as you read the law?
I'm not sure it is. I'm not sure. Maybe that's a question for the Solicitor General. But
it certainly is. I thought maybe I'd give you a chance, too.
So, as I understand the law, it's 270 days unless extended. And once that time runs, I'm not sure you're talking about an extension anymore.
Okay.
There's ex post facto law that kind of does this stuff.
Got it. Thank you.
Can I take you back, Mr.